Kia ora koutou, everyone. Welcome to today's session for the Hawke's Bay Chamber of Commerce Business Insights Series. I'm really glad you could join us today. My name's Jessica. I'm the event manager here at the Chamber. So just so everyone's aware, please know that this webinar is being recorded, and it will be available on the Chamber website for rewatching after this. Today's topic is, are you making lawful wage deductions, which is a very important issue for all employers, especially in light of recent legal developments. And we're joined by Myriam Mitchell, partner at Ashcroft Mitchell McGregor. Myriam has well over 18 years of experience in employment, health and safety, and dispute resolution, providing practical, legal, grounded advice to businesses across New Zealand. We will also hear from our colleague, Shoosh, partner at Ashcroft Mitchell McGregor. Shoosh is a highly respected immigration lawyer with over 9 years of experience working closely with both employer and individual clients to deliver strategic, tailored immigration advice. After their presentation, there will be a live Q&A where you can ask questions directly, and I do encourage you to participate in that and get the insights that will be most relevant to your business. You can also pop your questions in the Q&A throughout the webinar at any time, and we will address those at the end as well. So kia ora, and hand it over to you, Myriam.
Great. Thank you very much, Jessica. Thank you for the introduction this morning, and thank you for the opportunity to be partnering with the Hawke's Bay Chamber today to present today's webinar. And thank you again to Shoosh as well, who's joining us from Auckland. Love this new technology where we can just collaborate in a way like this wherever we are around the country. So as Jess has said, we're here today to talk to you about, are you making lawful wage deductions? There has been some recent development from this and from the employment court. Hopefully that's not the last word, and I understand that matters are progressing to the Court of Appeal, and there may yet be some further guidance in respect of this area, but certainly some groundbreaking comments from the employment court in certain aspects of the wage deduction field. And so we're here today to give you an update and a reminder in terms of what the legal requirements are when making wage deductions, cover this recent case from the employment court and some practical tips around how you can ensure compliance within your own business. So without further ado, we'll progress. A little bit about us. Jessica's done our personal introductions, but in terms of our firm, Ashcroft Mitchell McGregor, we have 4 partners, as you'll see on the screen here. We also have with the lady with the long blonde hair is Christy McGregor. She sits in our Tauranga office. In bright pink is Kate Ashcroft, who's also in our Auckland office, and I'm locally here servicing Hawke's Bay. We do all aspects of employment law, whether it is from upfront compliance or right through to the dispute resolution and dealing with those tricky personal grievance claims, or representation through the Employment Relations Authority or Employment Court. We also do independent workplace investigations where that's required, and all aspects of health and safety, again including compliance or then dealing with WorkSafe and engagement there post an incident or notifications, for example, an improvement notice. And these days, of course, highly relevant is the Privacy Act and the Official Information Act, or Lugoima for council. So a lot of space that we do in that. And as you've heard in relation to Shoosh, he brings an immigration perspective, which allows us to work both across those dynamics of employment and immigration where they intersect. And so he's appearing today to talk about the immigration impacts of the employment court decision that we'll talk about. So that's a little bit about us. In terms of what we're covering today in a little bit more detail, we'll be delving into the legal framework. So what is the Minimum Wage and Wages Protection Act? What do they say about making wage deductions? We will cover overpayment recovery rules because the seminar is designed a little bit to span both across those industries that work in the RSE sector, but also to explain the impacts of this employment court decision on other businesses. And overpayment and recovery is one of the common questions that we get from general businesses, where they've overpaid their wages or some other forms of payments due to employees, and we're always asked, well, can we recover that, and if so, how? We'll then go through the Soapy and Pick Hawke's Bay case, and I'll give you some updates in terms of what's happened there. And then Shoosh will take over for a minute and he'll talk about immigration and how that intersects with employment law. And then I will cover some best practice tips for you right at the end. So we'll jump into it. And as Jess has said, please feel free to pop into the Q&A at the top. Use that button, put your questions in. We'll be considering those as we go along, but there's also an opportunity to ask some questions at the end. So in terms of the legal framework, the two main pieces of legislation to bear in mind here are both the Minimum Wage Act and the Wages Protection Act. These set out a framework for, to ensure that employers pay employees correctly for the work that they have done. So broadly speaking, to ensure the compliance with this requirement that employees be correctly paid for their work, there needs to be compliance with employment agreements that you've set with your employees. If you're an RSC worker, also your immigration documents and your agreements to recruit, which I'll refer to as ATRs throughout this process, the Minimum Wage Act and the Wages Protection Act. And I should also mention at this point, of course, overlaying all of that as well is the Employment Relations Act and the obligations of good faith. So it's about remaining communicative, honest and open with employees. That certainly has relevance in the background of when considering wage deductions and engaging with your staff about their pay. So in terms of the technicalities, I'll keep these fairly brief because otherwise it's a lot of lawyers speak to take into account. But the main provisions of the Minimum Wage Act that you need to be aware of is really, well, first off, it's designed to establish legal minimum pay rates for employees, which we know. The Act sets out a framework for different types of minimum wages. So those being the adult training and starting out, etc. You'll all be familiar with this regime for sure, but this is just by way of scene setting to start. As we know, the Minimum Wage Act provides for annual reviews of the applicable minimum wage, so they shift every year, and of course with that comes a requirement to ensure annual compliance with those changes. There's also a provision not so well known within the Minimum Wage Act stating that their minimum number of hours in a working week is 40 hours a week over 5 days. Don't get too hung up about that though. Essentially, that is the provision unless otherwise agreed to in an employment agreement. So again, need to ensure that your employment agreements are quite specific and deal with the number of hours that an employee is expected to work, and provided you've got some clear provisions in relation to the number of hours, then you're going to be okay. The Minimum Wage Act also has some provisions, which I'll go through in more detail as we go through, about what deductions and how much can be made for board or lodging. And also worth mentioning is that there are some exceptions with the minimum wage around people with disabilities or, for example, prisoners. So there are some certain specified areas where the minimum wage does not need to be complied with. And if compliance hasn't been achieved in respect of the minimum wage, then obviously the employer is opening themselves up for enforcement or penalties from MB in the respect of fines or orders to pay arrears. And additionally, in addition to that, as Shoosh will explain, if there isn't compliance with the minimum wage, there can also be Immigration New Zealand ramifications with respect to that. Now, to get into a little bit more of the nitty-gritty of the minimum wage, Section 6 is particularly relevant, and this was a focus within the Employment Court decision that we'll be talking about, so I just wanted to spend a minute talking about Section 6 in particular. So we have a section within the Minimum Wage Act that says that despite anything to the contrary in any enactment, award, collective agreement, determination, or contracts of service, which are essentially employment agreements, every worker shall be entitled to receive from his employer payment for his work at not less than the minimum rate. Now, up to date, the approach that the majority of employers have taken is that provided the employee earns the minimum wage, then it has been considered that an employer can then make deductions from that minimum wage at source for payments that might be owed to the employer. For example, as was the case in this Employment Court decision that we're talking about in relation to accommodation or visa fees paid up front by the employer or accommodation costs. In other organisations, this might relate to training costs or the provision of a vehicle, or there are a bunch of employers that are quite often quite generous at the start of employment and may agree to advance wages up front for a piece, but then seek later to deduct that. So it has been the common approach to, when making those deductions, not really to worry about what amount of money the employee receives in the hand at the end of the day, so long as they are earning the minimum wage and ensuring, of course, compliance with that piece in terms of documentation. However, the landscape has changed with respect to that quite considerably, which I'll discuss. And the other section to bear in mind in terms of the minimum wage is that deductions for board or lodging or time lost are limited to 15% of the wages for board or 5% for lodging, lodging of wages, unless the cash value is properly fixed. So again, if you don't want to be restricted to those bare minimums of a 15% deduction for board or 5% for lodge, then we suggest that you ensure that your employment agreements very clearly set out the cash value of that accommodation that is being provided. Otherwise, you're stuck with the provisions of Section 6 of the Minimum Wage Act. Other key points in relation to the Minimum Wage Act is that a deduction, in order to comply with the Act, can't be arbitrary, and they need to be reasonable, but we'll talk about deductions when we talk about the Wages Protection Act. So the key provisions then, just to recap with respect to the Minimum Wage Act, is ensure that where you have got adults training starting out, employees, that they're receiving at least the minimum wage, that you're reviewing those annually, that you've got provision with your employment agreement about the hours of work that are expected, otherwise you'll be restricted to the provisions within the Minimum Wage Act, and you are ensuring that you fix the cash value of accommodation, otherwise again you're restricted to the caps that are provided for in the minimum wage. So that is a very brief description of the key provisions of the Minimum Wage Act. It's not a long or complicated legislation in itself, but has become complicated when you need to read it as against other provisions or other statutes, as we will see in the next coming slides. So turning to another key provision when we're talking about making wage deductions from employees' wages is the Wages Protection Act. So this Wages Protection Act really complements, or is designed anyway, to complement and not complicate the the Minimum Wage Act. It regulates how and when wage deductions can occur. So it requires written consent, and it also prohibits unreasonable deductions. Importantly, the Wages Protection Act operates subject to other enactments. So this includes the Minimum Wage Act, for example. So you'll recall earlier that I set out in an earlier slide that Section 6 says, despite anything contrary to any other enactment, award, collective agreement, determination, or employment agreement, the provisions of the Minimum Wage Act apply. And so if we flick back to the Wages Protection Act, when reading the two sections side by side, we've got some clear messaging within the Minimum Wage Act that says essentially it's to trump both employment agreements and other acts. So for example, the Wages Protection Act. In practice, this means that the Minimum Wage Act really sets an absolute floor for pay, like it's a baseline. Deductions can't reduce wages below the minimum rate is now what the Employment Court has clarified, and even if deductions comply with the Wages Protection Act, it becomes, or it being any deductions, they become unlawful if the Minimum Wage Act is breached, as now confirmed by the Employment Court. So under these rules, under the Wages Protection Act, all deductions must be reasonable. They need to be clearly authorised in writing. They need to be transparent both in their purpose and the amount. And it's very important for employers to obtain express consent for each deduction and to ensure compliance with the statutory limits, and failures to meet these requirements can result again in legal penalties and obligations to reimburse affected employees. For RSE workers, additionally, the deductions must be clearly specified in employment agreements that are submitted to Immigration New Zealand. Delving a little bit deeper into the Wages Protection Act, we can see that there are a little handful of sections that are particularly relevant. And I'll go through those now. So Section 4 of the Wages Protection Act says that no deductions can be made from pay unless they're in compliance with the Act or as set out in the Act. And so this is really an important Act, and it's important to be aware of the rules within the Wages Protection Act, because unless you're complying with it, then you are not allowed to make deductions from pay. Section 5 says that deductions can be made only with the worker's consent, and you need written consent, and you need to either have specific consent. So for example, if our company wanted to deduct wages from one particular employee in relation to, say, accommodation costs, we could have a consent form and a specific provision for the employee to fill out and provide specific consent with regard to that particular deduction. An alternative mechanism is to have what we call a general deductions clause within an employment agreement, and we will all have hopefully commonly seen those. It's a general clause within an employment agreement that gives the power to an employer to deduct in certain circumstances, say overpayment of wages or where expenses that are legitimately the employees have been incurred, and provides that consent mechanism in a general way. If however, an employer ever wants to rely on a general deductions clause and they haven't got the specific consent for deduction at the time that it's made, an employer still needs to consult with an employee before making that deduction. Now, note I say there consult, not agreement, and so you'd be writing to them, say it is an overpayment situation and you're seeking to rely on a general deductions clause. The practical mechanism for that would be to write, an email's fine, to the employee, setting out the circumstances, advising of why there has been an overpayment, what the amount is, a proposal that be deducted from final pay is quite often the situation, seeking the employee's feedback to that, and then the obligation then is to consider that employee's feedback before writing and making a final decision as to whether you would make that deduction or not. So it's really just following those general rules of employment about being clear and consistent and communicating with employees about what you're proposing will happen. Section 5A is relevant in the sense that it says that unreasonable deductions are not allowed, and Section 6 says that deductions for sets out some rules, for deductions for overpayment in certain circumstances, and I will go through in a subsequent slide some further details around deductions for overpayments. And Section 15 of the Act says that the Wages Protection Act is subject to other enactments. So that would include, for example, the Minimum Wage Act. Right, so that was a quick squiz through two key pieces of legislation and their key provisions that relate to wages deductions. And then I just want to kind of go into more of a general helicopter perspective and go through some rules around, well, what are lawful and what are unlawful deductions then. So it's important to understand what is permitted when we're talking about wage deductions. Lawful wage deductions must be supported by written consent from the employee. They must be clear. They need to have a legitimate purpose. For example, and the most obvious are statutory deductions like PAYE, KiwiSaver, court-ordered deductions. But other deductions, which are voluntary, can also be allowed, but where they are supported, as I've explained, by that written consent, and there has been some clear communication around that. The agreements for voluntary deductions might include things like for accommodation, insurance, union fees, visas, sometimes tools provided in advance or training, those kinds of things. These kinds of deductions become unlawful if they're for accommodation or lodging if they exceed those 15% and 5% caps, where the cash value hasn't been specified in the employment agreement, so that's important to note, or they result in the employee receiving minimum wage. Other things that are not lawful include charging employees for PPE. That's prohibited by the health and safety regulations, and employers must ensure that all deductions are documented, consented to. I know I sound a little bit like a broken record with respect to this reference to deductions needing to be consented to, but it really is an important central tenet of how these deductions work. And as you'll see by the employment case that we're going through, must not breach the minimum wage thresholds. So that's a general overview in terms of what is a lawful and what is an unlawful deduction. Let's talk for a minute about recovering overpayments then in a legal way. So what counts as an overpayment and what doesn't is the first question. Under the Wages Protection Act, an overpayment usually means wages that are paid by mistake or for a time when the employer wasn't legally required to pay. So common examples of how this might occur include payroll errors, misinterpreting the employment agreement. Sometimes employers make mistakes and overpay benefits like annual cash ups or annual leaves cash ups, but it can also include wages paid through periods of unauthorized absences, strikes or suspensions. So you might be in a position where you have made an overpayment and it's clear and it might fall within those categories, but recovery unfortunately isn't automatic. Employers must meet strict conditions. They first need to show that it wasn't reasonably practical to avoid the error, give written notice within 10 working days, act within 2 months in terms of making the actual deduction within that time, and get the employee's written consent or allow an employee to dispute an overpayment. On the flip side, it's important to also understand that there are some things that can't be recovered if we're talking about the area of overpayments. Intentional payments like bonuses or money the employee had then gone on and spent in good faith can't be clawed back. And if the recovery would push wages below minimum wage rate, then that too would be unlawful. So in the employment court case, Soapy versus Pick Hawke's Bay that we're here to talk about today, in Soapy the employer made an overpayment from one of the employees, Mr. Lau, which was considered unlawful as it was not authorised in a consent form, wasn't agreed to, it wasn't an agreed employee deduction, which meant that Pick Hawke's Bay couldn't rely on his consent to deduct. So the Soapy case is a good reminder that documentation and processes are really critical to ensuring a lawful overpayment recovery. I've got a little table here for you that sets out a bit more further information, summarises this all and pulls it together into one place. So this table summarises the key points regarding overpayment recovery. Looking at the can recover column here on our screen, you can recover for payroll errors, for misinterpretation of the employment agreement, i.e. you've interpreted a pay rate incorrectly, overpaid benefits, or wages paid during unauthorised absences. Right, so if we've established any of those particular categories, there remain, however, some conditions for that recovery. So you will still need to bear in mind the middle column, because there are conditions that must be met even where there is a legitimate overpayment before you can recover. So the employee must have the right to dispute the recovery. That is just being made aware in advance that the deduction is intended to be made and giving some information around that and the ability for the employee to respond. Written notice in terms of the intended deduction must be made within 10 working days. Recovery needs to be within the 2-week period and the employee consents in writing, or for example, there's an employment relations or a court order in relation to this. And the last column really is a repetition of what I've already gone through, but summarises for you what payments can't be recovered. And I should say as well that we will be sending a copy of this presentation to Jessica at the end of this webinar, and copies can be made available. Right, let's get to the crux of it then. The reason why we are here is a recent employment court case by the name of Soapy and Pick Hawke's Bay. This was released in around September, and is still being, considered by employment lawyers and employers alike to understand its ramifications. We do understand that it has been appealed to the Court of Appeal. We have heard some rumours that the Court of Appeal has allowed that appeal and that this will proceed and be heard by the Court of Appeal, but I haven't yet been able to confirm that, and it's certainly not up on the Court of Appeal's website just yet. It takes a few days for these things to appear sometimes. Well, what was this case about? So Soapy and Pick Hawke's Bay really is a landmark decision for New Zealand in employment law. It was decided by the full employment court in September this year, and it is a great illustration of the complexities around wage deductions for all employers, not just with respect to employers that participate in the recognised seasonal employer or RSE scheme. Pick Hawke's Bay has been an RSE since 2008, so that's quite some time. It's well experienced and has got great reputation in this space. It recruits seasonal workers from the Pacific nations. And in this particular case, it was facing claims against 3 former workers, Lynn Soapy, Danny Lau and Mary Lau, who were husband and wife, and they challenged the legality of various deductions that were made from their wages while they were employed by PIC Hawke's Bay. These included costs for accommodation, travel, visa costs, food, kitchen items, and personal protective equipment or PPE. The plaintiffs argued that the deductions breached several key provisions of the Wages Protection Act and the Minimum Wage Act and the Health and Safety at Work Act. And the case has attracted quite some attention, not only from the Employment Court, but also stakeholders such as the Human Rights Commission. And at the conclusion of the case, the Employment Court felt it was necessary to flag the decision to Immigration New Zealand to provide guidance to RSC employers and ensure, in particular, to assist with the process of ensuring that other employers were not making similar mistakes. And that is quite an unusual sort of step that the Employment Court took there in terms of that referral to the Immigration New Zealand. It doesn't happen all that often. So what were the legal claims? There were a number of claims that were made by the employees in this particular instance, including that deductions were made for overpayments and they were made without consent or written request, and that the way in which the deductions for the overpayments were made was in breach of the Wages Protection Act. They being the employees here, claimed that certain deductions breached the Wages Protection Act as they were not approved by the relevant ATR or agreement to recruit that was submitted to Immigration New Zealand, and or that they were not made in accordance with the Immigration New Zealand operational manual. They argued that deductions exceeded the 5% accommodation cap and therefore, again, violated the Minimum Wage Act. And they argued that deductions for PPE breached Section 16 of the Health and Safety at Work Act. And they also argued that deductions reduced wages below the minimum without proper authorisation, and hence there were allegedly further minimum wage violations. So what did the Employment Court find and what were the particular outcomes there? So the Employment Court found in favour of the plaintiffs on most claims, and it ruled that many of the deductions were unlawful, in particular where deductions from wages for debt owed to PIC Hawke's Bay, where employees were unaware of the debt recovery process until they arrived in New Zealand, and information as to how that repayment of the debt would work in practice was not disclosed to Immigration New Zealand and all the employees. The Employment Court also held that charges for PPE breached the provisions of the Health and Safety at Work Act, and the court stated that it was really the employer's obligations to ensure that it took steps to reasonably practical steps to ensure the health and safety of employees, and that there was a specific requirement as part of that health and safety regime to provide PPE, and it went on to confirm, as is set out in the Health and Safety at Work Act, that a levy or charge cannot be imposed on a worker for anything done or provided in relation to health and safety, and held that charging employees for PPE was a levy or a charge to workers and not allowed. So there was also a finding within the Employment Court decision that consent forms did not allow for deferred or pre-employment deductions that were being made. And in particular on this point, the court said that consent deduction forms did not provide a basis for PIC Hawke's Bay to defer a weekly deduction from one week to the next. And importantly, the forms were submitted to Immigration New Zealand as part of the approval process, but they went on to say were not referred to any part of the application to Immigration New Zealand purporting to authorise the deferral of deductions from one week to another, and in those circumstances it wasn't open to PIC Hawke's Bay to adopt a practice departing from what was consented to by the employees. It was recognised that Hawke's Bay was entitled to make deductions for costs such as airfares incurred prior to employees starting work, but the issue was that it started making deductions from wages, allegedly, before the employees started work and for a period that they were not receiving pay. And then there came the real surprising piece where the employment court also held that it could not make the deductions even where those were lawful, consented to by the employees, and Immigration New Zealand processes had been complied with, in circumstances where those deductions meant that employees were receiving less than minimum wage. There was, of course, some quite robust arguments that were put forward by both sides on this particular issue, with the employees stating, look, the Minimum Wage Act trumps the Wages Protection Act. The Wages Protection Act expressly says that it is subject to other acts, and the Minimum Wage Act clearly says that employees must be receiving no less than the minimum wage. There were then some counter arguments from Hawke's Bay around how the Minimum Wage Act should be interpreted from its perspective, in an argument that employees were still receiving the minimum wage, and that it was lawful because of the mechanisms under the Wages Protection Act to be making these voluntary deductions where consented to in writing, etc., etc. But just by virtue of the employees not receiving minimum wage in the hand by the time the deductions had been made, Hawke's Bay says that isn't a breach of the Minimum Wage Act. We were paying these employees, they were earning the minimum wage, the deductions came out after that. And the Employment Court weighed up various arguments from both sides, including previous decisions that have looked at the Minimum Wage Act and whether it's lawful, for example, for KiwiSaver deductions to be made and then employees receiving less than minimum wage, which was held in another employment court decision to be lawful. But in this instance, the employment court said no, those deductions couldn't be made because employees would be receiving in the hand, in their wage packet, less than the minimum wage. And that, as I've alluded to earlier, is quite a new understanding in terms of how we understand the two pieces of legislation to be operating. It was recognised by the Employment Court that may create some operational difficulties for REC workers and their employers and other organisations, but the view that the Employment Court took, of course, it's there to interpret the legislation and provide its views on that. It's really for employers then to find their own workarounds with respect to that regime, which we'll talk about at the end of today's seminar. So, what are the key takeaways then from this particular decision? Well, wage deductions must be lawful, reasonable and consented to in writing. There are mechanisms, as I've said, to do that by way of general deduction clauses or specific consent forms. Wages must not result in the employee receiving less than the minimum wage. Other workarounds will need to be adopted where the deductions result in minimum wage breaches. So, for example, a lot of employers are now paying the employee their full pay and then invoicing the employee for the costs that might have been occurred. Sounds a little bit of a ridiculous workaround in the sense that the money that changes hands is overall still the same. But there we go, that's what's required in order, at this point in time anyway, until the Court of Appeal has a further say, that is what is needed in order for employers to ensure compliance with the minimum wage. Additionally, for RECs, deduction from wages must be approved by Immigration New Zealand, but a cautionary warning there in the sense that immigration approval does not exempt employers from adhering to employment law obligations. So in other words, you might have the tick off with respect to your documentation that you've sent to Immigration New Zealand, but by no means is that any assurance from Immigration New Zealand that you are fully compliant with your employment law obligations. So the key takeaway in respect of that really is ensure that you are having external input and specialist advice with respect to how you're setting up your systems and your documentation. If in doubt, have those audited or reviewed, and ensure that you are working with a specialist in respect to that area. Other key takeaways include that accommodation, or with respect to accommodation, the cash value must be specified in the employment agreements. Otherwise, you're restricted to certain limits there in terms of what you can deduct, and employers must document the deductions and conduct regular compliance reviews. So that was my very quick summary of the Soapy and Pick Hawke's Bay case, and Shoosh will now take over and speak briefly around the immigration law aspects of this before we then talk about some practical tips and have a chat about your questions. So
Oh,
over
thanks for
to you,
that,
Shoosh.
Myriam. Yeah. So navigating the sort of area of overlap between employment and immigration as a result of the case, it's I think based on what Myriam was saying and in support of that, there is with the key takeaway. I think one way to sort of look at the finding from the case from a helicopter view is that immigration, in essence, take will complete a review of documents provided to it as part of a, for example, accreditation, agreement to recruit, NRIC accreditation application, or employer accreditation application. But in practice, um, when they're reviewing that document, it's not, I guess, a get out of jail card for if you're using the document or the practicalities of the scenario such that New Zealand's employment laws are being breached. So employers will just need to be extra careful or just attuned to an awareness that if immigration approves certain documents, that's not an exemption from complying with New Zealand's employment laws. And as this common law case suggests now, and it's law at the moment that we have to follow in regards to deductions, what that means that where there is crossover, for example, documents are similar to Immigration New Zealand, and the documents could be employment documents, deduction forms, and so forth. In respect to wage deductions, the approval of any type of immigration application doesn't mean that employers can rely on the approval from Immigration New Zealand to meet compliance requirements for employment obligations, e.g., under the Wage Protection Act and Minimum Wage Act. So, what employers will need to do is continue to remain actively compliant and seek employment advice in respect to scenarios where there are, for example, accredited employer work visa holders or RSC work visa holders that that they have provided a financial loan or support to and are potentially deducting or requesting that worker to pay back funds because, for example, as seen or as evidence from the SOP case, if an employer falls short on meeting these requirements and, for example, makes a deduction at source, so, for example, before the worker actually gets the money in hand, they make a deduction at source. Um, and then what the migrant worker gets in hand, if they get less than minimum wage for the hours worked, then based on this common law finding that from the SOP case, that's technically a breach of New Zealand's employment laws and requirements. And now, what this means with this dual sort of legal compliance is that if employers want to, for example, maintain a positive history of being compliant with immigration and employment law, they'll need to actively look at their employment relationships with their migrant workers who have been provided financial loans and so forth to make sure that the findings from the SOP case aren't being breached. Myriam will just move along from this slide.
second that. There you go.
Or because in the case, in terms of what was submitted, it was a high level of detail in terms of the number of documents that are provided and then the information that in the documents. So, for example, a particularized employment agreement was submitted. The documentation was reviewed by Immigration New Zealand. There was an approval, but at I guess what had happened was I suspect that the employer, based on the approval, thought, look, these documents were approved, my processes were approved, so this should be fine to meet employment requirements. And um, as seen by the court finding and what Myriam has talked about earlier, that wasn't okay to, in essence, rely on immigration having processed the documents to mean that the employer was actually compliant with New Zealand's employment laws. Moving along, Myriam, we'll just move to the next slide. Cool. I think this is the part that I wanted to focus on more, which is the wider implications for employers, because this case, even though it's a case where the scenario involved RSC workers, this has relevance also to accredited employers as well in two ways. So the first sort of impact that accredited employers should be aware of is that with the accreditation system, there's been a move away from the median wage rate to market rates. And what that means in effect is that previously what was happening is if you wanted to employ a migrant worker, you were paying them potentially at least $29 an hour. So there was, a bit of a buffer from minimum wage to what they were actually being paid. So previously, deductions could have been lawful just because what the worker was getting in hand after deductions was at least minimum wage. But now, with this shift from medium wage to market rates, which can be as low as $24, $25, it means there's less of a buffer and more risks that employers could potentially be actually at the moment. If, for example, let's say you provide a financial loan to your accredited employer work visa holder, and then you're deducting that loan at source from the worker's pay so that they're receiving potentially less than minimum wage in hand. There's a potential risk that, um, even though you're not employing RSC workers and only accredited employer work visa holders, that these new accredited employer work visa holders could be paid in a way that's non-compliant with the findings from the SOPI case. So that's the first takeaway in terms of the wider implications for accredited employers. The second one is if, for example, let's say you do employ, let's say, migrant workers under either the RSC or accredited employer work visa scheme, and then you're found to be non-compliant with New Zealand's employment laws, you as the key person associated with the employer, in essence, will need to have or need to take extra care when you help with future seasonal RSC accreditation applications or accredited employer work visa applications, because as part of these applications, there are declarations where you'll need to commit to having a positive, in essence, history of complying with New Zealand's immigration and employment laws. And if you're not, if you're not complying with New Zealand's employment laws, then that creates a risk and that will need to be dealt with as part of accreditation and wider immigration applications. So just to be attuned to this, I think. I think there will be employers that later on, maybe not right now because this change to market rate was just recently implemented, but I think in future, there's our recommendation for any employers that employ migrant workers would probably be to have a look at how you're making your deductions from your wages, and then to get some employment support to make sure that that the way that these deductions are being made is compliant, to make sure that your sort of wider immigration obligations and compliance requirements are being followed, and you aren't, for example, putting yourself at or your company or any employers that you help in future at risk of having a history of non-compliance through association with a key person um, that that might not have a good history or a history of compliance with immigration and employment requirements. Um, that's pretty much it from me, Myriam. Just back to you.
Great, thank you very much, Shoosh, for your input there. So this is our last slide before we move into questions. So put your thinking hats on, and now's your opportunity to engage with us. So just by way of wrap up, our practical tips to ensure the compliance and avoid legal pitfalls are: we recommend that employers are regularly reviewing their wage deductions and their forms and their documentation that they're using with respect to that, to ensure compliance with both statutory limits, the statutory requirements, and of course, the sometimes ever-changing immigration New Zealand rules as well, and obtain consent from your employees with respect to those reductions. Respecting the minimum wage requirements, so avoid voluntary deductions that lower wages below the minimum rate and provide legally required PPE. And when in doubt, use an alternative method such as invoicing or automatic payments. When I speak here to the slide where it says voluntary deductions, those are the deductions that you enter into with your employees with respect to accommodation, for example, the visa costs, the flights, all those types of costs. What falls outside of that regime are deductions that you are legally required to make anyway. They're not voluntary deductions, they are statutory deductions. So those are your PAYE, your IRD, or any deductions that a court orders be made for example, with respect to child support. So if it's deductions from wages relating to PAYE, IRD, KiwiSaver, something the court has ordered that be made by way of a deduction, you're still safe to make those deductions, even if it would result in the employee receiving less than a minimum wage. But if it's a voluntary deduction, there's a word of caution in respect of those. Ensure clear communication and documentation with employees. That really is going to be your biggest mitigating step. Time and time again, we find if employees understand what their obligations are, how the system's going to work, and it's clear and transparent and upfront, then quite often, even if there is a hiccup, that is an issue that can be resolved between employers and employees without them escalating matters to a formal complaint or a court process. Review your employment agreements regularly and amend them to comply with lawful deductions and the requirements within legislation, and carry out internal audits or seek legal advice with regard to your deduction processes. And I'd recommend certainly specific legal advice for any RSE employer. Every employer sets their processes up slightly differently, has different types or levels of deduction and wages that they provide their employees. So it is important that you seek specific advice for your specific situation. And of course, if you need further assistance in that regard, please feel free to reach out to either Shoosh or I, or both of us. We've both been working collaboratively, both with RSE and other employers, to ensure compliance, both with respect to employment laws and immigration at the same time. So that is the conclusion of our presentation and brings us to the question time.
All right, thank you so much. So we do have one question in the Q&As from Sue. And Sue asks, if RSCs want to pay into their home country superannuation scheme, would this be voluntary and allowed even if it takes them under minimum wage?
Yeah, so it really depends on how that scheme is set up and how the deductions for that are made. If the yes, it's a voluntary deduction for sure, and it would come under the provisions of the Minimum Wage Act and the Wages Protection Act if the a deduction is made at source. So what I mean by that is it being made at the time that the wages are paid and accounted for in the wage slip. So would need to meet the Minimum Wage Act requirements if you are calculating minimum wage and then deducting the home country superannuation amount and paying that offshore yourself on behalf of the employee and then giving the employee what's left. That wouldn't be allowed, because if that takes them under the minimum wage. But if the employee is receiving their pay and then making that transfer themselves after they've got their pay, then that would be fine. Any other comments you have on that, Shoosh?
No.
Oh, I see someone else has popped up a question or a comment around, can we get the slides post this, which we address throughout. We will be providing these to you, right, Jessica, and you'll be sending them out to participants.
Yeah. Yeah.
And as Jessica has said, a copy of the recording will be available as well on the Chamber website or your Facebook page. Where do they find that, Jess?
Yeah, well, I guess this is a good time to say that this Business Insights webinar is hopefully going to become a series, and not just with Myriam and AMM, but with lots of different other business leaders who have information to share that's really relevant to businesses and employers. And so we're going to be starting a new sort of section on our website. We have a tab at the top that's, I think, titled business support. So there'll be a new sub page under our business support called Business Insights or webinar or something along those lines. So I am interested in hearing what other topics are of interest. And we're hopefully going to be getting Myriam back and Shoosh as well throughout 2026 as things progress, not just with this case, but with other relevant information. But interested to hear what else everyone's interested in knowing about, or if you have any recommendations of other presenters for this webinar series, that would be really great.
Yeah, great.
I do
Thanks,
have a
Jess.
question actually,
Yes.
Myriam. So should employers be doing sort of an audit in what's been happening recently? What do they do if they do find out that recently they have done a deduction that's taken them under an employee under minimum wage? What should they be doing to mitigate that?
Yeah, absolutely. Look, the chances are that probably the majority of RSC employers have been making deductions under minimum wage, and our suggestion really there would be for now actually sit tight, because the commercial reality of rectifying that for everybody would be quite extreme, and so it is, unfortunately a little bit of cross some fingers and cross some toes at the moment in respect of past deductions that have been made. The concerning news in respect of that is that employees, when they making money claims such as wage claims, they do have a 6-year time limitation to bring that. That's outside of the 90-day PG time limit, for example. But certainly it's a matter of acting fast then, right, to ensure that you are now compliant and are not making any further breaches of the Minimum Wage Act or the Wages of Protection Act. And an internal or preferably external audit is a great idea, and certainly something that we can assist with should employers need that.
Right, we just have a response. Debbie has responded also to Sue's question. She says that they've been advised and this is in reference to RSCs wanting to make superannuation payments for their home country schemes. As this isn't going to the employer and they have chosen to have this come out, being voluntary, that it would be no different than KiwiSaver and therefore allowed to be deducted. Debbie says that this info came from NZEE. So
Yeah,
thanks,
great.
Debbie.
Thank you, Debbie, for passing that on. And I think this really highlights for us where there's still some room for debate and lack of clarity. Certainly, prior to even the Pick Hawke's Bay case, yes, there's been a case to say KiwiSaver deductions are allowed. But that the issue with that is it is payment into overseas voluntary schemes are different to KiwiSaver, or arguably there could be an argument that it's different because it's, KiwiSaver is part of our own legislative system. And so my suggestion would be err on the side of caution, but if you were, happy to sort of run with that advice, by all means do so. Shoosh, do you have anything you want to add to that?
I think it's probably just prudent to be extra careful if you employ migrant workers in this in the RC or career employer work visa space and are making these deductions. I think Immigration New Zealand's current stance is they're tightening up on compliance and audits and so forth, and you don't want something where you have an option to be compliant and then you choose to do something where there might be a question mark or a bit of risk, and then that creates the non-compliance. I think yeah, I agree with just erring on the side of caution.
And I mean, our hope is, right, that by the not too far into 2026, we've got a Court of Appeal decision and some different law on this, but we're currently stuck with what we're stuck with, including, I think, like aspects of that employment decision not providing the clearest guidance in respect of this area. So still some things to sort out in our legal system in respect of that. Any other questions from anyone else? Now's your opportunity to engage.
Please do.
You've got us as a captive audience.
All right, with that, I think we will wrap things up. Thank you so much, Myriam and Shoosh. Thanks everyone for attending. And yeah, please do get in touch with Myriam or Shoosh or anyone at AMM Law. Their contact details are on their website, but I'll also be sending out an email to everyone with these slides with their contact details. So that if you do have any questions, you can get in touch with them. And hope to see you all at the next Business Insight series. Thank you so much.
Thank you very much, Jessica, for arranging. And we look forward to working with you again next year.
Wonderful.
Thank you.
Thank you.
Bye-bye.
Thanks, everyone.